Prior to the Equality Act 2010, former employees were protected from victimisation against acts by former employers. Victimisation occurs when A subjects B to a detriment because B has done a protected act, such as bringing a discrimination claim, or when A believes that B has done or may do a protected act. Due to the way in which the 2010 legislation has been drafted, the position following the Equality Act is unclear. In a previous case on the issue, the Employment Appeal Tribunal held that the Equality Act does not provide protection against post-employment victimisation. However, the Employment Appeals Tribunal has held in a recent case that the Equality Act does protect individuals against victimisation after the end of employment. The case concerned a Nigerian domestic worker who brought claims against her Nigerian employers for discrimination and failure to pay the minimum wage. After the claimant had lodged these claims, her employer telephoned the claimant's sister in Nigeria and told her that the claimant would suffer for suing him. The employee then brought a claim for victimisation. The Employment Tribunal upheld some of the claimant's claims, but the claim for post-employment victimisation failed. Both the employer and the employee appealed the decisions. The Employment Appeals Tribunal overturned the tribunal's decision in relation to the victimisation claim and held that the Equality Act could be interpreted to cover post-employment victimisation. The Employment Appeals Tribunal considered that there was sufficient ambiguity about the proper meaning of the wording of the Act to enable the Employment Appeals Tribunal to interpret this in a way that provided protection for employees in these circumstances. This is a controversial decision in view of the fact that the Employment Appeals Tribunal have effectively reversed this decision made in previous case on this point. It had been argued that the wording of the relevant section appears to be very clear, and therefore there is a feeling that the Employment Appeals Tribunal may have stretched the definition of ambiguous to allow it to arrive at this decision. The current position is that there are now two diametrically opposed Employment Appeals Tribunal decisions, which creates confusion in this area. It is hoped that the government will take steps to legislate to clarify whether or not ex-employees are in fact protected from post-employment victimisation. For further information related to this or any other employment-related issues, contact our employment team.